Yeah.
What a setup.
Yeah, pretty cool, huh?
Yeah. So you got to feed right in the computer, huh? And where does it save it? It saves it directly.
Streaming live right now. Picking it up. YouTube. So, yeah. What do you think? Is it good enough?
No iPad today?
You can't hook up a webcam to an iPad. So I gotta use this thing. Else I would. I guess that's good.
Yeah, I don't keep up. Good morning, Carl. How are you doing today?
Morning, Stan. Good. How are you?
Good morning.
I can tell them these are come up with
I would try.
I have a friend who's an engineer, and he got pulled over for speeding, like, it's going like 55 and 35. Okay. And he had just, turned out of the parking lot, and he's not going that fast. And so he took the acceleration of his car, the distance between the parking lot and where he got the ticket, and did the math. And showed that it was possible.
I love it.
Yeah. His firm traffic ticket guy, very classy, very classy. His clientele is just really, really classy. The repeat customers, yeah.
Oh, yeah.
Yeah, and that's what he does, he looks for stuff.
Yeah. It's funny because there's and so the Chicago drivers will come up to the captain and Washington drivers will listen to Chicago. Because the Chicago drivers are like Boston drivers. You can't drive in that city once you're arrested. So if they come up to the captain, they still drive like in Chicago. And like, you're good neighbor now. But they think when they come back to Chicago, like, you can't cut it off. It just doesn't work. It doesn't work. Yeah. Right. Or purely technical. Just for today. I had a friend in Chicago. I couldn't drive in Chicago. You have to turn left. You have to get out. You wanted to and I just get me into the
I was saying Stacy yesterday.
until they stop. That's what I'm going to tell the police officer. Yeah. Sorry. Yes.
Order today. Good morning, how are you doing?
Right. I'm looking for a large constraint. We should get in line, trust me. Next time you say you are New Yorker. I know Jane said she.
Dr. Anderson?
Morning, everybody. Good morning. I just handed you an incomplete document, so.
We just figured out.
Dr. Anderson's gonna try and move around a few more, but I printed the odd pages.
We just figured out.
For our purposes also, we have caucus rooms. E101, you guys can take it out from E108. And that's just across here.
Right, the classroom building, E building, right across the building. You know, yeah, you can leave, exactly, but ask the Caitlin, right?
So C for you guys, we've got Articles 3 and 4, and those are missing, I guess, Article 3. We brought stuff on Articles 3 and 5, so maybe start with 5 all the way on 3.
Yeah, and I did not, I know I was going to go back and tweak it a little bit, but I did, but if you want to hand out here, you can start talking.
Yeah, we basically just took our article and pulled some of the stuff in from years that we talked about. So most of this we talked about, and I think we should be on the same page on many of this stuff. In section 5.1, we took the sentence from your proposal, and I think we took parts of our proposal. I'm just agreeing that the point of the procedure is to your article had the definition of a grievance rather than being a violation, alleged violation. I think we understand that, it's only really a grievance if the town actually sees a violation, so that's not something we had a problem with. Deleted all the, throughout the spelled out versions of numbers, we just left sort of the Arabic numerals. Not a big deal to us. And I guess white print makes it easier, so none of that was problematic. We, in section 5.3D, we struck references to AAA. Perfectly happy to use that. Perfectly happy to use the metropolitan panel, which I think pulls in from 125 miles rather than any of the larger ones. None of that's a big deal. So we've made changes accordingly. Moving on to the second page, page 14 of the document. Took a crack at writing some language along the line of what we discussed before about, either both parties or neither parties but the arbitrator want the transcript, then we share it. Otherwise, whoever wants the transcript, there's the cost. So I mean, we don't have an issue with the concepts, and we could crack it, writing language to that effect. If you want to edit that, or if you have an idea of your own, that's definitely something we're talk about. We also included some of your language, making it explicit. I think this was what we were assuming in our proposal, but we didn't have an issue making it explicit that, parties want to bring in expert witnesses and things like that to present their cases. That's a responsibility. Either party can compel the other side to contribute to that, including attorneys. In 5.4, you had some language kind of making explicit what it means to miss a timeline. We didn't have an issue with that. If agreement misses a timeline, that's it. They lose, and that's to withdraw the grievance. If the administration misses the timeline, that's the same as denying agreement. That's, I think, typically how it works anyway, so we didn't have an issue including that. We had a little bit of discussion about amending grievances. So in 5.4B, we kind of talked about, and you seem to be receptive to the idea of kind of having the same timeline for amending a grievance as the employer has to raise a concern about arbitrability. So basically within 10 days of the arbitrator's appointment, both sides have a responsibility to kind of finalize what it is they're either grieving or objecting to about there being a grievance. We also had a little bit of discussion about under what circumstances a non-member of the union has the right to pursue a grievance to the point of arbitration. And so here we clarified that if we're refusing to take grievance forward because someone's a non-member, then they have the right to do that themselves as case law has determined. So we're just making that explicit in the contract as well. We're a couple of things that we weren't comfortable putting in yet. For instance, and I think we can probably have more discussion about this once we get to talking about discipline, but you had a sentence in your section about arbitrator not substituting judgments for management. I don't think we have an issue with the concept, but because the kind of major circumstance where that comes up is in certain discipline cases. We didn't include that now, but they consider it depending on kind of where we can get on a discipline article. But I think other than that, I think we were really on the same page on most of this stuff. So that is our grievance procedure proposal for today. Any questions or thoughts?
No, not at this time. I think we'll talk a little bit during caucus.
Okay.
Remind me of the days, whether calendar versus business days, does your definition article?
Yeah, so in our definition article, Article 2, there's a definition of days that basically, the idea is just a day when the college does business. some sort. So whenever they call in for business, that counts as a day unless explicitly stated otherwise somewhere in the contract. I don't think it states otherwise anywhere in your superseding acts.
Yes, in our proposal, I think we had it in the agreement of procedure, yours covers the definitions, as long as it's in there somewhere.
And too many situations where people argue about what days means, I don't put the definitions in. Okay, so is this the revised?
Yeah, that's the revised version.
Well, we also brought some stuff on Article 3. So maybe the easiest thing, maybe we'll just do Article 3 and then we can talk about those other Articles 3 and 4.
That'll work.
Okay. So, and I think a lot of this stuff, again, as with the group procedure, a lot of the stuff that we pulled in from yours, we haven't done a whole lot other than that. I think a lot of language is really haven't. So the first major change you'll see, the severability article that you proposed, is a little more, I think, direct and specific as to what happens when the portions, declared invalid. So we replaced article 4. We thought that was a slight improvement. On non-discrimination, we included some of the stuff from your article about basically the right to belong to, participate in, or not belong to the union will be interfered with. We took I guess we kind of had questions about this, and then we talked about it, but we took our previous language around. It just says that the administration won't discriminate. You had some language saying the union won't discriminate. So we changed ours to say either the administration or the union will discriminate. We appreciated and therefore included your reference to genetics as not being a valid basis for discrimination. So we included that. Your proposal, I think, had some specifics, and I see them there in kind of your proposal today, some specifics on discriminating with regard to representation of bargaining unit employees, nor with regards to terms and conditions of union membership. That was intended to be strictly on those bases, not on just like you won't discriminate at all.
I'm sure I'm following you, Brandon.
So this was just something that generated some questions on our side. It says the union will not discriminate with regard to its representation of bargaining unit employees. But that's not meant to be the union won't discriminate at all. It won't discriminate on the basis of race, color, religion, etc. That was the intent, right?
Still trying to process what you're asking me, so the intent on you're talking about our language?
Yeah, so your language is that you have a clause that said the union will not discriminate with regard to its representation of bargaining unit employees. Now, if there's a period in that sentence, I think we would have to take issue with it.
Right, okay, I see what you're looking at, ours. So ours, I think they passed out the new ones.
Yeah.
Union will not discriminate with regard to its representation of bargaining unit employees, nor with regard to terms and conditions of union membership because of race, color, etc., all that. Yeah, so that the intent is not discrimination generally, but applying those same categories that apply to us.
Just for those two specific things. Okay. So, I mean, I don't think we have an issue with the concept. I think what I'm struggling with a little bit is how, well, not necessarily how it's worded, but how this is enforced, right? I mean, you don't usually see individual employees filing grievances against the union. So I'm just wondering kind of what happens if someone thinks that we violate that?
Well, we can certainly address that here. I agree, we don't typically see it in our proposal, today's proposal. If you want to jump ahead to that, we do address sort of the remedy, adding to your, our proposal is a red line version of your initial proposal. So you had a sentence in there that said nothing in the agreement shall be construed to deny or restrict members of the union's bargaining unit any rights they may have under applicable state or federal laws or regulations. We don't have a problem with that for the most part, but we add to that essentially this language that you see says if you're going to go and sue under state, federal, local law, that's fine, you have the right to do that, or you can file a grievance, but you can't do both. I think we talked a little bit about that. You can choose one or the other, so we fight in one form or another. If you want to add something here that, whatever in terms of violation by employee against the union, they have the right to, under state, federal, local law, limited to that, that's fine. I mean, I agree with you. I've never seen a bargaining employee file a grievance against the union on the union contract with the employer. I don't know that it's happened, but they would be able to try and file unfair labor practice or EEOC charge or lawsuit. That's typically where I'd see it come up. We tend to like to list them all out, so it does get updated pretty frequently, and we usually come back and we'll update it, but it's not usually something that's the problem with listing it generically. Just we won't discriminate based on applicable laws. Not always a consensus of what that is. The statutes are easy, but it's the case law and things of that nature. So I prefer to list it out, but this is one of those things where we're okay. I mean, we don't want to be involved in employee versus union dispute. And I know you've got your own bylaws and constitution for that sort of thing, but we'd be okay with having something there saying this provision is not subject to the grievance processes for allegations, something along those lines. For that, however you guys want to do, I do think it makes sense to have the non-discrimination standard in there for both us and you. Neither side will do so. It's good if anybody gets a challenge, and sometimes you end up with a challenge in agreements where employee files agreements against the employer, but they're really attacking both employer and you. Usually it's a non-member, but I like to be able to say, well, we at least all agree we're not going to discriminate. It's very much in facts, so it's case by case, but.
Yeah, I think we're not in disagreement that neither party should be engaged in any discrimination, so I don't think this is problematic.
Yeah, I suggest what you want on there. I think we'd be likely to agree on how to resolve potential disputes between union and employee.
Okay, moving down the list, we added a little slight rewrite of a sentence that we had in the non-discrimination tucked in here. It says that if there's a reference to any gender applies, a reference to a particular gender is always understood to apply to anyone regardless of gender. Looking at some of the other UFF contracts, this general provisions article is usually where strikes do get talked about, they get talked about here. So we took your strike proposal and brought a counter on that. It's pretty basic. It just says that, the parties acknowledge the laws, the union agrees that it will abide by the laws. The proposal had quite a bit of language that kind of went over and above that in terms of what the union must do. I guess if employees, even on their own, start talking about strikes, and when the contract is suspended, if employees do anything that's strike-related activity or something like that. I think think we certainly understand the employer's interest there. However, trying to find, what the original article that was there. I'm trying to find it.
For our original, I think it was the charter report.
That was part of it. Yeah, basically, we just adding a lot of extra consequences for employees who either strike or for the union itself, kind of over and above what the law already spells out, which is pretty harsh. I'm not aware of any state that has harsher penalties for engaging in strike-related activity than Florida does. So we don't really see a need to add to that. I guess in particular, the provision here that allows the college to suspend the terms of the agreement altogether, if there's something that it construes as a strike, I think I mean, we read that as obviously a pretty significant waiver language. We're not really interested in farming provision like that into the contract. However, we do acknowledge, the legal issues around strikes and don't have an issue agreeing to uphold the legal responsibility that we have. We're just not, I don't think, going to be interested in farming much beyond that.
What's the union's position on one of the things that we proposed in our no strike article is the ability to go quickly into court, obtain an injunction. With the timing is the issue there. I mean, we can always go into court and ask for an injunction even without it being in the contract. Under the law, though, typically you have to provide notice to the parties, except in very limited circumstances, imminent threat. So you can waive the notice, so it allows us to stop the strike quickly. If there is one, of course, you got to convince the court there is a strike. But,
what is the notice period? Not something I do on.
yeah, it basically you can get an injunction with notice and without notice. So you can get, there's no set time period. It's just you can't without notice. It's limited. You have to have imminent harm, physical harm kind of thing. So that's meant to somebody's about to go do something. You go into the court without the other side being there. So you get an injunction. The other side can then come back and decide and argue you shouldn't have been granted after the fact, and there could be damages if they misrepresented the court, for example. But for things that don't involve imminent physical harm, that kind of thing, then you usually have to make sure before you go to court, you give the other side notice that both sides are then at the hearing. Problem with that, from anything that you need immediate action, is it might take you maybe only one day to get notice to the other side. Maybe it takes 2 weeks or 7 days or whatnot, in which case then a lot of damage is done. It's not a huge thing. Obviously, we don't see strikes in Florida public sector very often, but it would allow parties to, whatever the dispute is, to argue about the dispute, but stop the strike in the meantime quickly. Essentially what that does. Not a big ticket item in my mind, but the union would always have the ability after an injunction is entered to stop the strike to go back and say, no, you shouldn't have entered the injunction. But in the meantime, the main difference is the injunction's in place while you fight about whether to put the injunction in place. The injunction, of course, is just an order that would say you can't strike, go back to work. Fairly low on the things that might happen. We recognize that, so
Yeah.
I just wonder if that's a concern or something that's pretty, it's not something that's in a lot of union contracts, but it's one of those things that to me is small potatoes. And you guys can talk about it if you have a discussion whether or not it's.
Yeah, we didn't get into the extreme hypotheticals on this. But I think, I understand the interest, we can talk about it. But I think definitely in terms of, adding additional penalties to employees or the union, or giving the employee the right to just ignore the rest of the contract, if something like that happens, I think it's pretty safe to say we're not interested in anything like that.
Well, and just so you know, so it's clear, that's not shock to us, obviously, but from the employer's perspective, the reason for that is we feel like if you go on strike, you're not upholding your end of the contract, so we ought to be able to say, well, if you're not going to work during this period of time, we're not going to continue and provide leave, that kind of thing, or anything else, so.
Yeah.
It's such a small possibility that I'm not overly concerned that this would be something that is a deal breaker if this is all that's left, so. But we'll talk about it, you guys.
Yeah, losing your pension doesn't keep you at work. I'm not. Yeah, I think you can be immediately fired in the statute.
Yes, don't go on strike, but court of law, as Graham says, is not very generous to striking public sector employees.
Yeah, there's not many states that allow it in the first place, but of the 40 or so that don't, only 10 of them actually have penalties. And 11 of them actually have penalties for striking, and court really is the worst. I've never seen these, unless something crazy happens.
And I think you're probably right. Well, while we're on Article 3, let's go through that part of ours. And I think probably when I'll go through and explain a little bit, we did similar to what you guys took the two proposals and tried to combine them, and based on your proposal today, maybe we can, when we break into a quick caucus, we can go through all of that. And on some of this, these general provisions are not all that controversial, obviously. So looking at Article 3 of our proposal from this morning, the duration part, I think obviously that somewhat hinges on the rest of negotiations. So I struck out your subsection B, which kind of reopener language, not because we wouldn't be amenable to something like that, but we really got to see what the rest of the contract is like. I think our wage proposal, I think we put in there contemplated, for example, whatever you have this year, you keep, and for the next couple of years, since we don't know budgets, you would have reopeners for that. So if that's the sort of thing you're thinking of, then certainly we'd be on board with that. I think we just have to figure out when we get there that we're all on the same page. Section 2, the supremacy and severability clause. Yeah, I think what you guys presented this morning and what we have here, we kind of tweaked your language a little bit. I think in caucus we can put those together and we're all on the same page on that. Basic concept being if any provision of our contract is later ruled invalid by statute or court case or whatnot, it's stricken. You obviously can't enforce it. It's invalid, but we agree to come back and renegotiate it as necessary. We didn't have a change to your first principle there that the agreement supersedes policy and rules and whatnot. That's something we don't dispute. The non-assignment, you'll see through this, I'm liking the term employer more than administration and board on most things. Some things, when it comes to the specifics of the board or administration, might be okay, but I've been going through and instead of using college, as we discussed in earlier meetings, using just employer. So we'll see that throughout some of this. It's not meant to change, I don't think, the intent of what you guys are doing, but there is on our side some sensitivity. There are some things that are specifically for the board, authorized by law, some things that are more president, some things where it's both. I think the term employer generally encompasses all of that. It's for us to figure out who has the authority on our side to do it. It's generic enough. The waiver, language. Here, I think the concept, and this is something we probably could put all of our proposals together, the concept I don't think we're in any big dispute. If either side chooses not to enforce something that we think you're not upholding your end of the bargain or vice versa, but for whatever reason, we're not running out filing grievances or whatever, you can't use that as a waiver to argue, well, you let us get away with it last year, so we're going to do it. We know we can't do that. It's just a matter of getting the language. I I didn't like your first sentence was a little bit too broad for my liking, to the extent that it talks about any question, controversy, claim. To me, I'd like to tighten it up a little bit. But pretty sure we can caucus and take what you did and what we did into some language that we all can live with. The non-discrimination, I like what you guys did probably better in here. I had it broken down at both of us, but I think obviously it makes sense. You guys proposed the non-discrimination on the employer side, we did on the union side. Let's agree neither of us will discriminate. I took the categories primarily from our board policy and updated it to things I think that are pretty safe to say the law clearly outlines discrimination, recognizing Mr. Horn says that these things change. Occasionally we'll update as we contract, these are kind of things you add. We didn't really like the political views. We used the term political affiliation in our proposal. And my primary concern with that is political views. If we went around and asked everybody what you think political views encompasses, we're going to get about 30 different answers. And for me, we don't want to have a lot of grievances or disputes over what somebody's political views are. I kind of know, I think what most of us think that term means, but if you're in a position where you're defending grievances from the employer's perspective, oftentimes there's agreement that's not being very reasonable, so what every unreasonable person thinks is encompassed within political views may not be. I recognize you can't discriminate on the basis of political affiliation, political parties, things of that nature. You have First Amendment rights, all these things. So that's the reason for the change back to our language, political affiliation. I did add the genetics one. When they first passed the Genetic Information Non-Discrimination Act a while back, I thought that was kind of dumb myself. Congress has better things to do. That was a while back, and sure enough, it was actually forward-looking because you already see some claims under it. So back when it was happening, the genetic testing and all that was very new. Who cares what your genetics are? So I added that in there, even though a lot of policies still don't have it in there, just because you start to see the claims. I want the employer and anybody to know that you can get sued for that kind of thing. So some of these categories too are expansive. Sex encompasses, I think, sexual orientation, gender identity under a lot of case law now, but I find it's good to separate that out because not everybody knows that. Ethnicity and national origin very closely related, but courts do make a distinction occasionally. So really, I don't think any of these categories other than the political affiliation versus political views is controversial. But what I wanted to make sure we did was to have the same applicable to both parties. So, and we could probably combine that as you did in one sentence, essentially, and state it more concisely than I did. The other big change that I already referenced was adding that language to subsection C, which is the grieve it or sue us, but not both language, essentially. And I also added, it's a little more wordy maybe than you. The reason for that, there's no pride in authorship here, so we can figure out a better way to say it on all ears, but we've had some instances where someone will file a grievance, go all the way up to the last second, and then withdraw it and file a lawsuit, or vice versa. So essentially, this is do one or the other, but not both. But once you make your election, you're stuck with it. That comes up where they're not getting a favorable audience, or you go to even in arbitration, you don't like the way the hearing went, so you withdraw it and go file a lawsuit. At that point, we've already spent a lot of time, money, so we don't care what the employee chooses to do, what the union chooses to do, just only do one.
So, this seems like an extreme hypothetical, but I've actually seen this. So, what happens if you have a union files a class action grievance that, a bunch of employees should have gotten some wage benefit, they didn't get it. Someone in the class action decides they would rather file an EEOC claim. How would this impact the status of the class action grievance?
My argument would be, I can tell you, is that they can't file a lawsuit. They may be able to get away with EEOC charge, EEOC will let them do it probably, but we would argue that the union has the ability to waive the individual rights and has done so by filing a grievance for everybody. We carve something out there. We have to talk about that on our side, but
I guess the bigger
employees stuck. Yeah, I mean, it puts,
Is the employee, is that individual employee stuck, or is the union stuck? Like, does that make the grievance moot because the employee went and did something? I don't know.
yeah, I can see the other side, they go first, file an EEOC charge, and then the union comes in afterwards, who does it. We'd be open to suggestions of how to handle that, if we want to have language in there. If we can, I don't want to make sure that we don't have multiple claims over the same thing in different forms to double the cost, but if it's something along those lines, it may not be that big a deal. We can have something that, I wouldn't want the class action involved, for example, but if an individual employee decided, just as in most court cases, class action, you can opt out and do your own. Maybe something along those lines, you can add language there. They can't be a member of your class and also sue us. Maybe that's the answer.
Yeah. Yeah, I just don't want to run into a situation where someone goes broke and it screws everybody else. I think we get it, it's a pain in the neck, waste of time and money, and spend yourself in two forms of the same thing.
We'll kick it around in caucus, but I think maybe that, the way they do that in class actions is the way to do it. If they want to opt out, that's fine. But they don't get the benefits of your claim, you don't get the benefits of theirs, and vice versa.
Yeah, I think we can figure something out, that's just something I haven't seen happen, so.
The last section of printing and distribution, we struck out printing, we'll make it available electronically. I don't know if people still print these things. We can make it available electronically, and everybody can print their own, but I don't think people care if you're using our printer, but I think we talked about, we don't want to just print 100 copies and then post at it, but it's online, so.
Don't you know, be worried about is the very somewhere on the website, as long as it's somewhere that's very easily accessible. As opposed to like trying to find an IMS.
There is
scavenger
suggestion we
hunt.
have the time to hunt around to find, so it should be readily available.
Because IMs are a scavenger hunt right now.
Yeah. We can talk about it on our side, maybe we can consensus.
The legal policy side.
Yeah, so legal
And you can go search for it.
Yeah, on websites, and you know, they're always changing and whatnot, but we can talk about it. I think we all agree it should be readily available, not too difficult to find. And we're not necessarily opposed to putting out some hard copies. We don't have the obligation to print for everybody, and a lot of people just don't use them anymore, which is an unnecessary cost. But if we want to have maybe a handful or on request, somebody really wants a hard copy, I don't know that that'd be a big issue. So that's Article 3, the general provisions, I think, on these are where I don't know if we have a TA of the entire thing, but a few things are still sticking points. We could always break out a few of these into separate necessary, but I don't think we're that far off on the majority of Article 3, which is not too surprising. If you want to segue to Article 4.
Just one of the question that you said the IMMs are difficult to find.
Oh.
And then the internal website.
So the internal website is right on the right-hand side.
To know what they are, and where they are, not
The actual
It's hard to find out what you're talking about.
I am 1-12.
Just search.
You have to search the whole thing to find out what you're looking for.
Well, that's different from, can't find.
Well, they were in 2 or 3 separate places as of December.
They are.
We
They're
first
on
started
the-
pulling-
They're on the website and they're also on the internet.
I meant like within the website and within the internet, you have to look at least 6 months ago, you had to look, actually a little longer, you had to look multiple places to find them. In other words, when it wasn't like they were all in one link, you had to go to different places on the website. It was like a scavenger hunt.
Well, all of the IMFs and board things are on one page. So on the internet. And then on the intranet,
when you go to the link for IMMs and board rules, it takes you right to IMMs and board rules, so there's no difference. But I agree with you, when you go to that board rule, you'll have to search to see what it's all about.
Right, and there is a way of titrating that down by category. So the board rule section, there are 6 or 7 categories of personnel, general provisions, facilities, et cetera. So if you click that, it will navigate you directly to all those board rules that are relevant just to that category. So we do have that drop-down menu option as well.
Correct, so personnel would be under personnel.
Right.
For the board rules, we have expanded on the site, so it gives a little bit more of a
We do.
description of what it
When you
is,
click on it.
which is something we could probably do with the IMMs to help out with that same thing. It's a little bit more what the content is in detail than just the title.
They're in that table, so you can just put some summary information on the table, if that helps.
Yeah, I think everybody's interests are aligned on this, try and make it easy to find. It's just a work in progress. And it's one of those things that I personally, I can tell you that board rules are easier to navigate. The IMMs, I don't have access to all the stuff, but I can get those and do find, I have to search through 20 of them to find the one I'm looking for. But we recognize that, and that's one of those things that we've got to improve on. For the union contract, it'll be at the end, one main document put there somewhere, and we'll make sure we all know where it is. The IMM, I think, from my perspective, one of the difficulties is it's broken up into many different documents that is not searchable, so that's what we're trying to improve on that.
Sure. But we also have categories in the cabinet where you have like the faculty handbook, standard class sizes, CAA manual. There are different documents on the left side of my cabinet. So that would be ostensibly an opportune place to also put this for all faculty to be able to have access to it.
Yeah, and these are the kinds of things too, as we're going through, not necessarily for the union negotiations, point these things out and try and fix it, recognize there's a time element in the cost and staff to do it. It's not as easy as I think some of us, the non-IT people, think you could just do that quickly. And I know from talking to Dr. Hartz that that's not always the case. So, but it's one of those things where over time it's going to totally get easier. And anyway, all right. So Article 4. I want to talk about Article 4. Union rights article. I don't know if you want to go through, or if I want, I'll tell you, walk through. We have ours in there, so where we're coming from on some of these ideas. So our dues deduction, we're not terribly far apart on dues deduction, obviously. That's provided by statute. We recognize and acknowledge our obligations. Dues deduction, I did take the additions really are from our language. I think relatively standard. We are comfortable deducting dues with proper authorization. We don't want anything to do with any disputes between union and employee if there's some dispute over whether amounts or whether we should. So we included an indemnification paragraph that said you guys fight about it, essentially, not us. Obviously, the last part too, I think under the law, we're not supposed to be deducting penalties and assessments and that kind of thing. So we wanted to add that language, make that clear to employees. Section 2, use of facilities. Our proposal here is we are agreeable to the union use of facilities. In our view, we want to ensure that the union follows the same process we expect of everybody else. We are willing to, for your routine meetings and business meetings, things of that nature, to do it without charge, allow you that use of a facility without charge. But we want to still go through the process. Maybe Dr. Gina can sort of, I have languages very generically. You have to do it the same basis as everybody else, but if you want to kind of speak briefly about what that process is.
Certainly, thank you. Customarily, our standard practice and protocol with third parties is to charge for use of facilities, vis-a-vis the conference room or a classroom, etc. However, we reserve the right on a case-by-case basis based on the relationship that that third party has with the institution to waive a rental fee. And oftentimes we charge for the security if necessary and for custodial and maintenance for setup, takedown, etc. In this case, we are open to, of course, providing with no fees to the United Faculty of Florida to use our classroom and or a conference room for business or sundry activities. However, we ask again, as Mr. Koji indicated, that you also follow the customary practice, and that is whenever there's an interest in reserving the facility, you make initial contact with the provost's office. The provost's office reviews the master facility utilization calendar to make sure that it doesn't conflict with any other activities, etc., classes. If it's available, then they'll tentatively schedule that, reserve that, and then we ask the organization then to complete an activity form that indicates the date, the time, etc. There should be an administrator who signs off on that, and then it comes to the provost signs off on that, then it goes to our facilities team, and then it's yours to use for that stipulated time frame. So that's essentially the process that we undergo at this moment. So long as we continue that process, there should be no problem. And already, we've begun this precedent here already with the union activities. I think on all of our campuses, you all have had meetings, and you have appropriately gone through the provost's office and obtained the signatures, etc. So that's our request.
Okay, so can I continue?
Yes, that's reasonable.
Yeah, I don't think it's been working so far.
We were not agreeable to the second section. The use of the mail, and particularly the email system, is not something we're willing to agree to at this point. College-wide email system, college is protective of that as a college business.
Can I ask a question about that?
Sure.
If we agree to not have that, would the administration also agree not to put anti-union clauses through that system?
Not likely to agree to that. For several reasons. One was anti-union rules, and I know we would agree, but the bottom line is the college has the ability to use its own system to present its position on any issue. It doesn't automatically then open it up to debate for everybody else. Now, we're beyond the unionization effort, so I don't know that I would anticipate much of, if any of that. During the union election campaign, obviously, there was some of that. But that's over. We accept the result of that, so I don't anticipate that it's going to be a sticking point. But we also don't want to open up the system to just anybody else. Recognize, too, if you do that, then you open it up to others, you rival unions, things of that nature. You don't see that very often in higher ed, but from our perspective, college needs to have a mechanism to be able to clearly articulate its message on a variety of things. It can't be, we all have spam and everything else, but what happens is you want to send out something, if it's just a, hey, there's a union meeting next month, this probably wouldn't be a big deal. It probably goes beyond that, and next time someone wants to send out a message, well, what about this legislation in Tallahassee or whatnot? Here's the union's views. College may have a different view, and now employees are getting messages, whose views are these? We don't have any interest in doing any of that. So today's day and age, it's very easy in our mind for college as a union to, anybody who wants to receive your emails, put together your own distribution list and have that go through personal emails and things of that nature. Bulletin board, the next one is something that's pretty standard. We have no real issue with that. We wanted to suggest more specific language. I put 3x5 bulletin board. It's just a suggestion. I don't know what our sizes we typically have. If you have, that was more standard boilerplate from my perspective. Each campus you can have it. We want to be able to dictate the location. So what we have in mind is a bulletin board that employees would see, but not necessarily the same boards that students would use, things of that nature. Or one where we have our legal notices, there'd be a separate one for the union to use. We can put in, I don't think we did put in the actual buildings, but talking about faculty, workshop areas, those kind of things, what we would have in the workrooms. And we can debate those if you feel there's a better one, but we do want, if we're gonna allow the use of bulletin boards to be used for union business in the sense of advertising, your meetings, things of that nature, not as a gripe board, I'd say. And unfortunately, it happens a lot, so we don't necessarily need to have approval authority of everything we put on the board, but we would want to be able to see what goes on the board and not have it just be one of these gripe boards. So that's the language and the rest of that. Moving on to section 3, got any questions on that? Union office, we're okay with a union office, but that we would charge on a rental, suggested $100 a month, $400 a semester. We don't have a lot of space. Your proposal asks for not only an office, but a conference room, dedicated conference room. We think that's not realistic space we have. Having said that, as per the section 2 up there, when you need to use something for a meeting here and there, go through the process. We're not opposed to doing it, but having a dedicated one just for that is, I think, something we're not willing to agree to.
And that fee is our customary standard fee for office rentals. So our university partners who currently occupy an office space on our campuses, that is what they pay.
That's fine. Access to faculty, we're agreeable to the concept. We have some tweaks here. We are willing to allow the union to piggyback when we're doing orientations. What we've presented is not necessarily that you'd be involved in the orientation, but you can provide forms or packages, authorization for dues, membership to us, and we'll make it part of that process. We have one of these all college day, all those kind of things, subsection here. We're not agreeable to add the union as part of the regular agenda to that, but we will agree to allow you to, after that's done at the day, if you want to have a meeting, piggyback after the fact, we'll work with you on that. Anybody who wants to voluntarily attend can. We're not going to make part of the agenda you're required to attend and be voluntary. You can hold your meeting on the same day, that kind of thing. So that's the intent of the language for subsection B. Access to information, I think the only real change here is two things. One, we want to make it clear that we're okay with providing all the information. I think it's all pretty much required on the public record as well, but we want to make it clear that it's on request. Whenever you want it, come ask for it, as opposed to just us doing it, because I can tell you whenever we have it, it's not on request everywhere else, we forget to do it, or we don't want to fight about it. If you request it, we'll get it to you, basically. I did add language at the end of that to the extent it's available online on the electronic system, we can direct you to where it is as opposed to having it printed out. I don't know if we need to say that, but if it's hard to find stuff, I can see why you have a concern, but we can direct you to it. Because more and more of this stuff is starting to be put online. Also, the last thing is, this is one of those articles we think should not be subject to the grievance process, or at least not arbitration. If you want to tweak that, okay with that. The reason being twofold. One, you can file unfair labor practice if you truly think you're withholding information you're entitled to, and two, if it's public record, you can file a public record lawsuit, which we don't want, but we don't want an arbitrator trying to figure out what PERC should be handling or what public records are. Consultation with the college president, we're okay with that. Instead of making it automatic, it's on request. And we put or as designee. There are times when the president might think provost or VP or someone is a better person, depending on whatever topic you want to discuss it. the president is committed, he's invited, he'll meet and work with you guys as necessary, so he certainly will make himself available. But there are times when someone else may be better to meet with. That's really the reason for that language. The release time, we're not agreeable at this point. I think release we want to handle separate from this because it's going to overlap with some of the topics down the road and will likely be the kind of thing that will certainly have provisions on release time in the contract, but will likely be, in our mind, more of a package with other proposals that we're not yet talking about. So that's why I struck it, not because it's necessarily out of the question, but just something that we're going to need to talk about down the road in future sessions.
Are you referring to things like, costs of paying someone else overload to do it, to pick up the class, or an adjunct, or whatever? I was wondering if there's like specific articles you're interested in talking about in relation to that.
Yeah, I mean, it's really all of that stuff. We haven't had in-depth detailed discussion about that. It's also something that, to the extent there's release time associated with providing union representation, whether it be bargaining grievances and things of that nature, that's something that is valuable to the union and to the employees. And it's something, as you said last time, I think, so that we have to buy some things from our perspective. It's the same here, that so it's better to package those together. You guys want this, we're not necessarily against it, but we're also going to want some flexibility in other areas, and it makes sense to pair those together. So the concepts here, I don't think we are. I can tell you when we're reading through it, the discussion is probably a little bit generous on some of the hours and things of that nature, but we'll want to certainly negotiate over those things as we go forward. But concepts of having some time for these things is not out of the ordinary. So that's really all we had for today, and I don't know if you have anything else or if you want to discuss or questions. Otherwise, I think we can break out amongst ourselves and see if we can hammer out language on some of these things. Yeah, did you get the minutes? Did we circulate the minutes? I don't know if we approved.
I'm not electronically.
I was okay with everything. I don't know if we did for the last meeting.
I'm fine with electronically, but if you brought paper.
I did.
You want to look at them, see if we have any tweaks. It's about 10:30 now, so what's your preference?
Yeah, why don't we, let's try and take half an hour, maybe we'll look at some of this stuff and sort of talk. I don't know that there's whole articles that we want to sign off on, but we can at least say, oh, the section two, the section two.
Yeah, that makes sense. Why don't we do that? You guys are E101 again, or E101? Yes. All right. 11 o'clock.
Yeah, and,
You want
we'll start telling the,
to?